Hello. So that I've
For
heard.
my sake.
Yeah, totally. Well, that's what she keeps talking. I said, we're gonna follow every rule. No one wants you to get that license more than me.
Yeah, well, it's like, if she fails, it's gonna be.
The tip I've heard for girls that they have long hair, I've really heard this from like the mom friends.
Good morning.
Aren't you insightful to immediately pick up
You know
on
what,
it? It makes sense. You teach acting school.
Tail, if it's true, but that's the tip for your knee.
I will let her know
Can't
that.
hurt, right?
Should we go?
Good morning.
Commissioner Hastings, how are you?
Wonderful.
You said that with a fair amount of authority.
It's another beautiful day.
Yes, I bet it is. Okay, well,
I'm sorry.
welcome to the Commission on Governmental Ethics and Election Practices meeting for February 2024. We'll start right off with agenda item 1, which is ratification of the minutes of the January 31, 2024 meeting. Will anybody have a motion?
I move to ratify the minutes.
Second. It's been moved and seconded that we ratify the minutes. Is there any discussion? Any amendments to make? I didn't see any either. Since we have somebody remote, we'll do the votes by roll call today. Commissioner Newman,
Yes,
Commissioner Marvel,
Yes.
Commissioner Hastings,
Yes,
Commissioner Leclerc,
Yeah.
and I'll vote yes as well. Moving on to item 2, the public hearing for rulemaking on the election spending by foreign governments issue. I'll open that public hearing. I see that we've gotten a couple of written comments. Mr. Wayne, would you like to start us off?
Sure. This relates to a citizen initiated law that was approved by the voters last November. It requires us to do a rulemaking. The law is intended to prevent foreign governments from making expenditures or contributions to influence elections in Maine. So the commission staff, in consultation with the AG's office, drafted some proposed rules. And the rules define certain terms, give some guidance on the types of entities that are covered by the new law. It's intended to provide some guidance to media companies about how they can adopt policies that are designed to avoid publishing some of the prohibited messages that are sponsored by foreign governments. You approved a rulemaking at your last meeting. Comments are welcome through March 11th. And I know there are a couple of people online who would like to comment, and there's at least one source here in person who would like to comment.
Great. Mr. Moulton, do you have anything to add?
Yeah.
Okay, great. I'd like to recognize that we've gotten written comments from the Advancing Democracy Through Law and the American Promise organizations, and I'll accept those into the record. And is there anybody present who'd like to speak about the rules? Please come up and.
Travel the extensive distance between here.
Exactly. I hope it doesn't wear you out too much.
Good
Please
morning.
introduce yourself and tell you.
First of all, distinguished members of the Commission and Governmental Ethics and Election Practices, I appreciate the opportunity to comment on the proposed amendments to the Commission's rules to implement 21 AMRS 1064, prohibiting certain entities from making contributions and expenditures with regard to Maine elections. My name is Tim Moore, and I'm the President and CEO of the Maine Association of Broadcasters, a nonprofit organization representing the interests of over 150 television and radio stations throughout the state of Maine. As you are aware, the MAB has joined with the Maine Press Association to seek permanent injunction against the implementation of this law, arguing that it is both unconstitutional, a clear violation of the First Amendment, and also that it's both vague and unreasonably burdensome to media outlets, tasking them with the responsibility under the threat of fines and penalties of somehow investigating and documenting the specific source of funding for any and all entities wishing to place legitimate political speech on our outlets. Such a requirement would be close to impossible for Maine's broadcast stations, many of which are small family-owned operations. While Maine broadcasters share the concerns of election interference from foreign influences, clearly the public does as well, given the margin that question 2 passed. This law, in our view, does nothing to address what we believe are the true concerns of Maine voters. Barrage of social media infiltration by foreign governments with sinister intentions, millions of bots, and now the prospect of deep fakes and artificial generative intelligence designed to deceive. No, what we believe is a simplistic referendum question, the goals of which prohibiting foreign election interference, everyone can agree on in principle, was actually a thinly veiled attempt to silence Maine's electric utilities from participating in a political forum that would impact hundreds of thousands of Maine residents, the thousands of Maine people who are employed by these companies, and the tax burden that each Maine citizen could be saddled with. Because these American companies have a degree of foreign ownership, this fact was seized upon as a means of eliminating one entire side of the debate over whether the state should take over Maine's electric utilities. Now, to be clear, the MAB took no position then, nor do we now, regarding what was question 3 last November. We do find it somewhat interesting that the very same electorate, which resoundingly voted in favor of question 2 on foreign election interference, also voted overwhelmingly against question 3, a government takeover of Maine's electric utilities, which are at least partially foreign owned. Now, in the legal arguments, there have been interpretations of case law and statutes, precedents, and all the other scenarios that are being used to make the case. Unless you're a lawyer, much of this is in the weeds, but laws can dictate outcomes and sometimes unintended consequences. Regardless of where one stands on this issue, one thing is for certain. Had this law been in effect before the last election cycle, it would have been illegal for Maine broadcast stations to air any political ad against the state takeover of electric utilities. Illegal for the utilities to make that position, their position, known. Illegal for broadcasters and newspapers to accept these ads. Those in favor of such a takeover would have been the only voice allowed to be heard. Proponents of question 3, those who cried foul for being outspent by the utilities, a situation they could have addressed with perhaps more robust fundraising, instead apparently believe that the remedy to being outspent is to completely silence their opposition, making it illegal for these companies to participate in a public policy debate upon which their very survival was at stake. Had only the pro question 3 voices been heard, Maine people would have been forced to make their decision without hearing both sides, just one side, which we believe is contrary to the ideal of robust American political discourse. Without both sides being heard, the outcome could have been completely different. Does the state have the right to silence a legitimate political voice, citing the possibility of foreign influence without a shred of evidence to back it up? And by selecting a percentage of ownership out of thin air as the threshold for eliminating these voices, we believe they do not. The MAB position has been mischaracterized as to be advocating for foreign advertisers. Maine broadcasters are not advocating for advertisers, foreign or otherwise. We're advocating for our audiences, the people of Maine, whom we believe are entitled to hear all political voices in a public debate. And we are adamantly opposed to any government-imposed ban on these voices. Governor Mills also cited her concerns about the constitutionality of what was then LD 1610 when she vetoed that legislation, at which point proponents then placed it on the ballot. We wholeheartedly agree with her decision and have included her letter to the legislature last July explaining her reasoning in our submitted documents along with our declarations. Since as of this writing, unless something's changed in the last 24 hours, Judge Torreson has yet to rule on our petition for permanent injunction. So we respectfully ask the commission to refrain from taking any action with regard to rulemaking until that decision is handed down.
Thank you.
Thank you.
Do any commissioners have questions? Commissioner Hastings?
No.
Okay. Do you want to submit your written
Yes.
comments?
Yep.
Terrific. That would be great.
I just have one brief,
Yeah.
I'm sorry.
Yep.
I have slow brain. So the Maine Association of Broadcasters has how many stations you represent?
Over
Broadcast,
hundred and fifty,
these would be FCC licensed entities,
correct,
not private cable or anything like
correct,
that.
just broadcast over the air FCC stations.
Okay. And, if in fact this law does go into effect, would the Maine Association of Broadcasters provide assistance in the form of model rules to comply with the, is that something that you would normally do? Do you help your members understand and comply with federal regulations?
Well, we don't act as legal counsel for them. The rules that they would be following would be yours. We feel it's gonna have a chilling effect on political speech of any kind. Because the way buys are placed, radio stations and a lot of political stuff is done through an agency. There's no way for a broadcast station, again, often small businesses, to discover what the source of that funding is. And so we feel it's gonna have a chilling effect on all political. I think that a lot of, as much of a revenue source and a valuable revenue source it is to our stations, we feel that a lot of political ads, unless they're, national candidates, and a lot of questions will be turned away.
I'm just gonna get back to my question about if in fact this law is deemed to be constitutional, and there's a provision in here for stations to enact have policies to help screen out foreign influence. Would the Maine Association of Broadcasters in any way be part of promoting some sort of model station policies for your members to follow?
Premature to say that. Again, we don't, and not to repeat myself, but we don't act as counsel, and I think a lot of those decisions are gonna be made on a day-to-day basis, whether we put out some kind of blanket, be careful. I think that would be it. If you don't know, then you're gonna have to run it to your legal department, and a lot of stations, their legal department is either non-existent or it's a single attorney. And that is probably not conducive to buys, which often are placed on one day that start the next day. The time frame just is not amenable to that.
So you're a membership organization?
Yes.
Yeah.
Yeah.
All right, thank you very much.
Commissioner Marble?
In the early third, I think, of your testimony, you brought up a subject which I think resonates with a lot of people. Frankly, a lot of people care about democracy. You were citing, I think, a combination of social media and dark money, with unregulated, unresearched messaging. I'm not trying to paraphrase what you said, but and what I'm just wondering is, as the Association of Broadcasters, how would you differentiate, and I'm really asking this out of ignorance, the safeguards in information promoted by the broadcast stations against that sort of slope? What's in place now to assure the public that what they're getting from information is factual and reliable and not driven by untraceable sources or money?
Well, I think a lot of it lives in the digital world, so it's apart from what we do on a day-to-day basis outside of the websites that our stations have. I'm not entirely sure that I follow the question with regard to safeguards. I mean, most campaigns that occur in the state are candidates, probably the murkiest segment would be the issue advertising, because you don't know necessarily where it's coming from. The association would certainly not be opposed to safeguards that the commission felt were important to guard against that sort of stuff getting on the air. But I think that within most broadcast operations, the questions that land on the ballot and that are of public knowledge I think are pretty self-explanatory.
Well, I guess, and I'll drop this in a second, because I'm not crystal clear where I'm headed for this either. But I am thinking of a real life example where I'm thinking of a radio station that offers opinions, that brings guests onto its show
Mhm.
who may well be offering opinions, sometimes almost as facts, where the source of their information is at least questionable. And I'm wondering what's in place now to put guardrails on the fact that the source of that information could in fact be foreign derived very easily.
Well, and that could be, and that's, those are First Amendment rights in the context of a campaign. If a candidate is coming on and making those assertions, then there's an obligation for equal time.
This is non-candidate. This
Right,
is
this is somebody that's getting on the radio and
regular guests.
spewing whatever they want to spew. I mean, that's, like it or not, that's our system.
Okay, but what I do never hear from the station is any disclosure of the source of the information being broadcast.
If a guest comes on the air and cites a
Then it's
source,
hands off, First Amendment.
well, the station was not the source of the false information, if you're talking about false information. I mean, we are a forum, so that's, it's saying in a call-in talk show that a caller can get on the air and spew lies. We know there are prominent national politicians who do that as a regular course of business. That's, whether you like it or not, that's the First Amendment.
Thank you.
One more brief. How many commercial television stations are there in the state of Maine?
Well, there's really only about a dozen. There are some low-power TV stations that some of them are construction permits, not on the air yet. Some, to be honest with you, I don't know if they're on the air because it's kind of on one week and off the next, but
Commercial entities or,
yes, yeah.
so of the 12 commercial entities, how many are owned by, entities that have, for example, other stations in other states or?
Most of the television stations are owned by bigger corporations.
Do we have any in Maine that are independently owned?
Not in the commercial realm of the major network affiliates are larger companies.
Okay, so there's no like family-owned commercial television station?
Well, WVII and TV Channel 7 in Bangor, their Fox affiliate that's a smaller company. That's not like Hearst or.
So like, for example, up in Aroostook County, where I'm from, we have one commercial television station serving both ends.
WAGM, and that's great television, and they own.
They're fairly large.
Yes, yeah.
And, I'm not sure, they used to run all three networks. I'm not sure if they do anymore, but.
Yeah. Yeah, they do.
Thank you very much.
Any other questions or comments? Thank you for your testimony.
Oh, wait a minute, Mr. Chairman,
Yeah,
Commissioner Hastings, I do have a question at this point.
please go ahead.
Okay, thank you. I understand that the Association of Broadcasters would ask that the commission not take any action on this at this time, but we are in a public hearing on these proposed rules. And I wonder if the association would be willing to comment on, assuming that this law is found constitutional, are you willing to comment on the safe harbor provisions provided for in the proposed rules? Does the association believe those are an effective and relatively easy way for the members of the association to avoid liability under this statute? Have you reviewed those safe harbor provisions, and are you willing to comment on them? Do you have any?
I have not reviewed them. Are you referring to the general FCC defined safe harbor after 10 p.m. or is that a safe harbor that is defined elsewhere in Maine?
as I understand it, the proposed rules before us now do contain a safe harbor provision.
Yeah, I think he's
that
referring
allow
to
any broadcaster or advertiser medium to avoid liability by obtaining a written statement from the proposed advertiser that they are not an entity that's subject to this law.
Is this the checkbox that I was hearing about? That,
Section 8B.
okay, I have not reviewed them enough to make a comment on it, so.
Question.
8B provides a safe harbor. I mean, that's, so the association has no comment on that proposed rule then. You simply want us not to act at all.
Well, right, and obviously that's not up to me to determine, but I guess I'm gonna ask again, is that safe harbor, is that what was referred to as the checkbox for basically,
Well, I would assume that the association had reviewed this safe harbor provision.
we
Which
didn't put the cart ahead of the horse because we weren't sure that those rules, we were hoping against hope that it would be deemed unconstitutional.
well, we are having a public hearing to consider them at this point. So this safe harbor provision allows a broadcaster to avoid any liability simply by having a statement signed by the proposed advertiser that it is not an entity subject to the prohibitions, and to maintain that list, maintain that for a couple of years. I guess I was hoping for a comment from the association as to its as to the efficacy of that provision, whether that would be burdensome or not.
I don't think that would be burdensome at all, but we would wonder whether or not anybody willing to check, anybody in legal entity and illegal entity placing ads on broadcast stations would already be circumventing the law, and I don't think that, and as was argued in court, would have any compunction against checking a box. And broadcast stations aren't certain that they would still not be liable, even if anything, because the entity checking the box, giving us the broadcasters the safe harbor would be the advertiser.
Well, it
And if
does
the
appear,
advertise-
it appears that the
advertiser is
association has not
illegal,
reviewed this at this point.
I'm sorry?
It does appear to me that the association is not focused on this provision of the proposed rules and
Well, it didn't appear to be in the legislation, and whether it appears in the rules, but what was in the legislation was stations were liable for due diligence, fines were outlaid. The checkbox seems to be something that came later down the road, if I'm not mistaken. I don't believe that there was any due diligence requirements were in the original bill, and we didn't know what that meant.
it appears that you have not reviewed the proposed rules in detail.
I would tell you that I have not reviewed them in detail, no.
Thank you.
Thank you. Any other questions, comments from commissioners?
I guess I'll just say, as has been noted, if the law, we have to make regulations, and so what's the date that the public has to comment until again?
March 11th.
March 11th?
Okay.
So if MAB wants to comment before March 11th. that could
Yeah, if
potentially
you want
be
to
very
submit further
helpful.
comments, you're welcome to do so until March 11th.
Yeah.
And you're welcome to give your written comments to Mr. Wayne if you'd like. Thank you for your testimony. Is there anybody else present who'd like to testify? I think we've got, do we have Mr. McKean?
Hi, good morning. I'm Mr. McKean. You can call me Aaron.
Oh, terrific, thank you. You're here to testify about the rule and election spending by foreign governments?
Yes, we are. And I'll just intro here. My name is Aaron McKean. I'm legal counsel with Campaign Legal Center, which is a nonpartisan nonprofit that works to advance democracy at every level of government. And we strongly support the commission doing this rulemaking, providing rules ahead of the 2024 elections, making sure that there is sufficient guidance for folks trying to comply for the regulated community and for the public. We really appreciate the rules that you put out. And so what we've done is submitted written comments in response that are a bit more detailed, just to go through some of the more, nuanced, some of the more nuanced wordings that we would suggest. But I did just want to testify this morning to highlight two, bigger picture items that we've included in the written testimony. And those are going to be the public list that's proposed in the rules.
Again, I'm sorry, the public what?
The public list requirement
Yep.
that's proposed in the rules, as well as the definition of the internet platform. And our goal is really to strengthen these rules. We think they're a great start, and our recommendations are simply just to make sure they're kind of fully comprehensive, and don't leave out any particular issues. So I'm going to start with the public list requirement. And with that one in particular, our primary concern is that we make sure that the commission is providing sufficient guidance to the regulated community about the operation of the law. And our recommendation is that we actually expand that provision. So instead of providing like a public list that is updated, I guess, every once in a while, whenever the commission takes action, we're suggesting that you instead provide broader guidance, right? So the commission already provides really great resources on, compliance for committees, for candidates, for the Clean Elections Act. And what we're suggesting is that you can provide similar guidance and specify it in the rules for the act, right? For the foreign interference prohibition. I'm sure that that might already be in the works, but we thought it would be helpful to specify that it'd be broader, providing advisory opinions if somebody asks for them, noting on the website where when the commission has made a finding of that denotes that a entity is a foreign government or a foreign government influenced corporation, providing those resources in a repository in the online website would provide broader materials for the regulated community. And then one of our concerns with the public list is that it might not stay updated, right? You might have a finding by the commission that an entity is a foreign government influenced entity, and then they go on the list, but then just sometime later they might no longer qualify for that definition. And we wouldn't want there to be confusion about whether they're actually a foreign government influenced entity or an entity that if they've no longer qualified, they really shouldn't be on the list, right? And you might have confusion there for media providers who are trying to decide, should I be selling this ad to the foreign government influenced entity? Our suggestion is instead that we don't need the public list itself because it could lead to that confusion, but instead providing that broader guidance will help with compliance for the regulated community. So that's the first one I wanted to highlight. And then the second one is the internet platform definition. And our primary concern with this definition is that it unnecessarily narrows the scope of the law. The law specifies that it applies to internet platforms. And there are a number of suggestions a couple suggestions that we have here that would instead make sure that it applies to all internet platforms that are selling ads to Maine residents that are going to Maine residents, assuming that they're selling like campaign advertisements above a certain threshold. So folks are concerned about small internet platforms having to take on extra administrative burdens, and we think providing like a minimal threshold of advertising as sort of a qualification for becoming regulated in this way would help assuage those concerns. So, when we look in more detail at the internet platform definition, one of the big pieces that we noticed is that it focuses on media providers or platforms that are providing advertising directly or that is primarily intended for Maine residents. And our concern is that might be too narrowing, like I was saying earlier. So on the media provider side, one of the concerns is it focuses on like print media, right, is one option under one type of media provider. And the way that it's defined, you might end up with a situation where like a regional newspaper or a national newspaper has their online website where it's selling ads to be viewed by Maine voters, but it's not going to be captured by this definition because it doesn't actually it doesn't publish content primarily intended for Maine voters, right? The New York Times might not consider themselves to be primarily for Maine residents. The other aspect of that would be we want to make sure that streaming services, right, like TV streaming services are included too, because places like Hulu or Netflix or Amazon, they're starting to sell advertising, with political advertising. And when they sell advertising, it could go to Maine residents, but they wouldn't necessarily consider themselves, primarily focused on providing content intended for Maine viewers. And so we want to make sure those are covered as well. Those are the two kind of big pieces that we've suggested, recommendations for. The other ones are a bit smaller, although, I'm more than happy to talk about any questions you have or provide any other assistance that we can for the commission.
Thank you very much. Are there questions or comments from commissioners? Commissioner Martin?
Just a first blush at this reaction. If I were in membership with the Association of Broadcasters and I saw a line that said, I should have known of an entity status as a foreign government influenced entity, that would make me a little concerned running to attorneys. I'm not sure how I should have known that. Just to say for the record, some of this is going to test the capacity of commission staff if this continues, I think, and I'm just trying to be supportive. I would ask Jonathan, if I may, do you have any comment where the history of the commission and some of the procedures and rules and regs around things like PACs and donations are going to start interfacing with this? Should this become law of the land? Do we have a library of things that are translatable and applicable, or is this going to require, you know what I'm getting at?
Yeah, I mean, the law conceivably could cover PACs, which are unincorporated associations of people, if there were foreign government influence. I think we were viewing this as sort of a standalone topic, but I'll think about it.
No, that's helpful.
Any other questions or comments from commissioners? Commissioner Hastings?
If you wouldn't mind if I respond to just the note about the should have known piece, since you picked it up, would that be okay? The key piece about that recommendation is, ensuring that when a broadcaster or some other media provider, actually goes through the process and sells an ad, if it's so obvious, right, that an organization should be considered a foreign government influenced entity, right? Like that's what we're trying to get at, right? You might have a situation where the commission has, made a finding, right, that a particular entity is foreign government influence, and you issue a press release, you issue a big fine, it gets lots of coverage in Maine, right? And in those cases, there should, the commission really, this is more about what the commission can do. And the idea is the commission really should be able to, say, look, it is so obvious. It was covered in all the papers. It was covered in all the newscasts. It is, beyond belief that you are unaware that this entity could be foreign government influenced. And that's the key we're trying to get there. Because you could have a situation, right, where someone says, look, all of the stations covered it except for one. And that one station decided to sell this ad. are you going to be able to provide, actual knowledge that, or prove actual knowledge that that provider, they knew, but they sold it anyway, right? We don't want folks to be reckless about it. We want folks to actually do due diligence. We think the safe harbor provision does a great job. We've suggested a couple amendments to the safe harbor provision, like removing that public list requirement. But otherwise, I think the safe harbor is a really strong, illustration of how this can work and how it can work, without a big burden on broadcasters. The FCC has their own version of these of a due diligence provision. They put out rules in the last couple of years on this. The FEC, the Federal Elections Commission, similarly has safe harbor provisions related to foreign spending and elections. And so, that's kind of what we were looking at, when looking at, what the Maine Commission has proposed here. And then in terms of the burden on, administrative staff, certainly, I think that is a big concern. We did raise later on in our comments with respect to the disclaimer requirement. There's a provision that allows, like an advertiser to provide a little bit more context for why they're including that disclaimer on their issue ads, saying, we're a foreign government or foreign government influence entity. And it allows the advertiser to explain a little bit, these are terms of art in Maine. Maine law defines us as this, and so that's included. But we thought it would be a big burden on the commission staff if that was sort of an open-ended invitation to those advertisers to have to, or to be able to kind of freelance, right, and include extra information that goes beyond, what the commission has suggested. So, later on in our testimony, you'll see we've suggested limiting that and just saying, look, advertisers can provide that extra bit of information in their disclaimer, but otherwise, we don't need to get into, the commission doesn't need to get into telling folks what to say or what they can or cannot say or what's truthful or accurate. And we thought that could be actually a bigger burden for commission staff that would want to, kind of guard against.
Thank you, Mr. McKean. Any other questions from commissioners or comments?
Do you know?
No.
Oh, just briefly, so you are opposed to a list that's in section E? Is that correct?
So we think the list could actually be broader, right? Instead of providing a list and requiring a broadcaster to check that list, we think that could just provide more guidance ahead of time, and it could be more comprehensive, right? So I think the concern with the list is it could cause confusion down the line, right? If I'm a foreign government influenced entity, which I am not, just to be clear, if I was that kind of entity, right, maybe I get put on the list by the commission, right? It goes on the website. But there could be confusion later on if I'm no longer, right? What if the foreign government owner no longer owns, over 5% of my corporation? There could be sort of like a time gap. There could be confusion between media providers and the advertisers about whether they qualify or not, whether I would qualify or not. And we wouldn't want that to get in the way of, the advertising they should be able to purchase.
So, I mean, I understand you're wanting to broaden the use of a website for public resources regarding compliance, but the rules limit it to a list on its website of all entities that it has determined in enforcement proceeding. It's not like there's some sort of onus put on the commission to go out and find foreign entities. It would simply be a recitation of entities who have been determined through enforcement proceedings to have met that definition.
Right, and I think maybe that gets at, one of the specific issues with that particular provision, right? If you're creating that list, we think it's great to provide, the evidence of those findings, right? If you want to, we think it would be, an excellent transparency measure, right? Make a make your finding about whether an entity is a foreign government influenced entity, and then post that finding on your website, have that available for folks to be able to see, right?
But isn't that what this is? I mean, it's
Well,
a list of
if-
entities that have been determined through enforcement proceedings to have met the definition.
Right. And I think
it's just historical fact at that point.
no, I completely agree with that part. You know, if we go a little later in that particular provision, right, it says that the foreign government influenced entity has to petition to remove themselves, right, from that list. And, you know, we don't think it's actually not, you know, if I think the way I'm conceiving of it is this is a list of your enforcement proceedings, but you wouldn't, I don't think you would erase or remove, you know, evidence of your enforcement proceedings from the website, right? And so, you know, that adds confusion there. What are they asking to be, if I'm understanding you right, you know, that this is just a list of the enforcement proceedings, then what are they asking to be removed from, right? Like that would be the concern.
There could be an additional entry that simply says what the later proceeding is that resolved their status. So you're right,
Yeah.
not, yeah. Okay.
Yeah, and I think
So it's not a list itself you're opposed to, you'd like to see it done accurately or better?
yeah, I think as long as it's, you know, accurate, it's providing, you know, what the commission has done. You know, I think instead of, I guess the way that I read it when I first went through it, it seemed like, oh, this is a list that's going to sort of exist separate from, you know, the specifics of the documents about the enforcement proceedings, a separate list. And then it would sort of live separate from that. And that would be my concern. And then by sort of making this broader and providing, you know, the enforcement proceedings pieces, I think you also don't necessarily need to have in the safe harbor provision, you don't necessarily need to have media providers checking that list, you know, they can rely on, right, the information provided by ad purchasers, and they can rely on, you know, their knowledge, right, if they have actual knowledge or if they should have known. Like those are the pieces that we want to focus on, as opposed to having all these media providers trying to, you know, rely on that list.
Yeah, please.
Doesn't that somewhat cut against your, should have known additional suggestion? In other words, if there's a list that indicates companies that have an enforcement provision been found to meet the definition, isn't that part of what you're saying, that advertisers, if that list exists and it's publicly published, then it could meet the should have known requirement? So I guess I'm just wondering why you don't want a list. I mean, I think we can all agree that the list should be as accurate as possible, but
Yeah, I think just through this sort of discussion, I think I should probably make it clear, I'm not against like a list of enforcement proceedings. I think my concern is if you had a list where someone had to petition for removal, right, from a government list, like that would be a concern, right? I'm not opposed to a list of the commission makes findings all the time, right? And, you know, we're able to go look those up. And it's my understanding is like this kind of finding, this kind of enforcement proceeding should be available, you know, just as anything else is. What I'm worried about is that sort of time element, right? If you're saying, if maybe, you know, you do find that you have that enforcement proceeding posted, and that's good information for people. And, you know, it's possible that that's a factor, right, in considering whether they've met that should have known standard, but it might not be the whole story. And we wouldn't want necessarily that folks, you know, end up confused about who's on the list, why are they on the list? Limiting that list to enforcement proceedings and saying here on, you know, X date, we found this to be true. You know, all of that sounds fine. I think the concern is, you know, once you're 2 years in the future, then what happens, right? Have things changed? We wouldn't want that list to be, you know, perceived as, you know, the end all be all until someone petitions for removal. That would be the concern there.
Any other questions, comments? Commissioner Hastings?
No, thanks. No.
Okay, thank you, Mr. McKean. We appreciate it.
Thank you.
Is Ms. Lacasse here? Lacasse?
Yes, hi, thank you so much for the opportunity to speak today.
Did I pronounce your name right?
It is LaCase, but that's okay.
Sorry about that.
It's all right. There are many of us in Maine and different factions of the family say it differently by this time. So many generations of us. So good morning to the members of the Maine Ethics Commission. My name is Caitlin LaCase, and I was the campaign manager for Protect Maine Elections. Thank you for the opportunity to submit comments concerning the Commission's proposed amendments to its rules to implement 21A MRS 1064, which prohibits foreign governments from making contributions and expenditures to influence elections in Maine. Protect Maine Elections is the ballot question committee formed by Maine voters in response to the Federal Elections Commission's ruling that it had no jurisdiction over state referendum campaigns. This ruling created a dangerous loophole that allows corporations owned and controlled by foreign governments to spend in referendum campaigns unless explicitly prohibited by state law. This initiative closed that loophole and put elections back into the hands of Maine people and out of reach of foreign government-owned entities. On behalf of Protect Maine Elections and the 86% of Maine voters who supported this law on Election Day, thank you to the Ethics Commission staff for their careful drafting of these amendments, and to the Commission members for the thoughtful conversation during the last meeting and during today's meeting. Protect Maine Elections supports the amendments as drafted, and this law is more important than ever. According to Maine Citizens for Clean Elections, the entities that are owned, controlled, and or influenced by foreign governments spent more than $100 million on Maine ballot initiatives between 2020 and 2023. Last election cycle alone, such entities were responsible for 83% of spending. Alarmed with this trend of out-of-control spending by foreign entities, a record-breaking 86% of Maine voters voted in support of this initiative. This is the largest margin of victory on a Maine statewide ballot initiative in the state's history, ever. The only opponents, it seems, of this initiative are the very foreign entities that are seeking to preserve their power and the media corporations that are the biggest benefactors in the political spending arms race each cycle. Maine voters delivered the clearest of messages on Election Day, telling the moneyed interest in the political class that we are taking our government back. And frankly, we are outraged that these entities are currently challenging the law in court in an effort to overturn the will of the Maine people, who spoke with a near singular voice on November 7th in support of protecting our elections from foreign government interference. Again, thank you to the Ethics Commission for continuing to move forward with the rulemaking process.
Thank you very much. Are there comments or questions from commissioners? No. Commissioner Hastings?
No.
Thank you very much for your testimony. You're welcome to submit written testimony until March 11th.
I'll submit it, the written copy as well. Thank you.
Terrific. Thank you very much. Are there anybody else wish to testify on these rules?
Is there anybody from the CLC here?
I think they just, well, that was Mr. McKean.
I think you mean,
Oh,
the
American Promise.
thank you.
Yeah, I don't think so. Okay. They just submitted a written comment.
Excuse me, were you referring to CLC?
He was just
I
asking.
was mistaken.
Oh, okay, thank you.
That having been said, if there's nobody else who'd like to offer oral testimony, we'll close the hearing on the
before
rulemaking.
you do, can I just
Yeah.
say one thing to the extent that anybody else is
Sure.
listening? I might go without saying, but I find the written and public comments specifically on the language of the rules very helpful, whether we adopt the recommended changes or not. It's food for thought for the commission, and I think will make the rulemaking and the ultimate rules, should the statute go into effect, much more robust. So we appreciate your comments.
Mhm. Whoever imposed this process was pretty wise. So I'll close the rulemaking hearing and we'll move on to the next issue. Agenda item 3 is late notices by Our Power to two major contributors. Mr. Wayne, would you like to tell us about it? Sure.
Last November, Maine voters considered a citizen initiative to bring a new utility to Maine that would transmit electricity. And Our Power was a ballot question committee that was promoting that initiative. In August and October of 2023, it received contributions from 2 contributors that in the aggregate exceeded $100,000. So that meant that Our Power was required to send written notices to those 2 contributors, advising them that they needed to file major contributor reports with our office. Our Power did not send the notices to those 2 contributors on time, and under this reporting statute, there's a penalty process if the ballot question committee or PAC is late in sending out the notices, and there's a preliminary penalty, and the ballot question committee or PAC is allowed to ask for a waiver. So the staff sent the ballot question committee a notice that the preliminary penalties for sending these notices out late was $28,144. And the ballot question committee is here today to request a waiver, and they offer mitigating factors. Commission staff has taken those factors in consideration, and we recommended a reduction to a total of 15,000, which is not as low as the ballot question committee is asking, but we know there's 1 or 2 representatives of the committee here to make their case to the commission, and we look forward to participating in any way you want, but above all, we respect your right to adjust upward and downward as you think fit.
Terrific, thank you. Are there questions from commissioners for Mr. Wayne?
Oh, yes.
Yes, please.
Yes, as Commissioner Hastings, I'm wondering if there's a typo here on page 2 of the staff's discussion in the boxes at the bottom with the key dates. Under notices sent, when I look at, I'm not sure that, especially under ILSR, that the notice was sent on August 17th, which would have been before its due date. I'm looking at the forms that are attached, the actual filings. It appears that the notices for both of these were sent on November 9th, and I wonder if that's just a typo.
That was a mistake. I appreciate Commissioner Hastings bringing it to our attention. Those notices were either sent on November 8th or November 9th, both of them.
There's a lot of dates flying around here, so it's
Yeah.
easy.
You have a good eye, Commissioner Hastings.
Mhm.
Okay, thank you. Thank you, Mr. Wayne. Thank you, Commissioner Hastings. Is Mr. Friedman here to discuss this with us?
Yes, I am here, and I believe John Brodigan is also attending in person.
Terrific, yeah, please have a seat. And you guys can organize this any way you wish.
And Gary's gonna start us on.
Yeah, I thank you. I appreciate you bringing me in by Zoom today and the opportunity to explain our position.
Sure, please introduce yourself.
My name is Gary Friedman. I'm the treasurer of Our Power, and I'm zooming into you from Bar Harbor.
Terrific, thank you.
Okay, thank you. And I've been on the board of Our Power since its founding with John. And I just would like to paint a picture of this campaign for you really briefly to put this whole issue into context. This was a very low budget campaign for Our Power. We're a scrappy grassroots organization. We had 2 full-time employees working on the campaign for a total of 8 months each. And then we had a very small number of short-term and part-time staff assisting them with the campaign. This was essentially a volunteer staffed campaign. And our group during the campaign was under constant attack with misinformation and lies from the opposition, which often the political action committees of Versant and CMP often spent more money in 1 week than we spent in our whole campaign. And this was really a campaign of, by, and for the people against 2 foreign corporations. We never meant to hide or obscure anything. The 2 contributions in question were given in the midst of a heated campaign where every volunteer and staff person were working around the clock to keep all the balls in the air. And we admit the mistakes that were made, but ask for leniency and consideration that there was no malintent or no harm to the public. Our power was doing the best we could to comply with all the reporting requirements in the face of obscenely funded opposition, stopping at nothing to preserve their highly profitable Maine franchises. John will elaborate on our stance, but I want you to know that as a former president of Maine Citizens for Clean Elections myself, I tried hard to live up to the reporting requirements, and I've learned my lesson in this case. Our request for a reduction in the penalty reflects recent precedent and factors for determining a penalty, especially that there was no harm to the public. And John is going to supply more background for you. Thank you.
Thank you, Mr. Friedman. Are there questions or comments from commissioners for Mr. Friedman? I will say that I reject your claim of being a little mom and pop operation, because you spent $1.2 million between 2020 and 2023. And I reject your claim that there was no harm to the public, because these contributions weren't disclosed until after the election. So the public was denied the information that they were entitled to if you followed the rules. But that's just me. Mr. Brodigan.
Thank you, Mr. Chair. Members of the commission, my name is John Brodigan. I'm here to follow on Gary's comments. I'm going to give you a little bit more background, and then I'm going to walk through the factors that I believe should inform your decision. And let me say, first of all, we agree that with the facts in the commission's memo, we don't contest that there were violations. This is mostly about the nature of the campaign and the factors that should be considered in determining a waiver in whole or in part of the penalty. A little bit more background. We had a small group. We began to work on this in early in 2020, February 2020, and then COVID hit, and we really didn't do much for a while. We eventually registered a BQC at the end of 2020. I think it was in December. That year, we raised a grand total of $5,000. We always were a modest grassroots campaign. We were not really anything comparable to the multi-million-dollar BQCs that you've seen in many of the other major contributor cases that have come before you in the last few years. We had a tight budget, and we raised most of our funds from small individual contributors. Gary already noted that we had a small staff and we had a lot of turnover. We did not have legal counsel employed by the campaign. Nonetheless, through this period of time since December of 2020, we had an exemplary compliance record. We filed 29 campaign finance reports totaling over 500 pages, all of them on time, no errors or anomalies or glitches as far as I know. Gary and I personally reviewed and signed off on each and every one of those campaign finance reports. Like many campaigns, the reports are generated by staff who go through and input data into the form and then generate a draft report for others to review. And that's how we conducted our oversight of the staff. We correctly reported 2,752 itemized contributions, including 2,088 contributions of $100 or less. We received about 2,000 unitemized contributions, which were correctly reported. We correctly reported 1,251 expenditures. To put this in perspective, one of the BQCs that recently violated the major contributor law received a total of just 11 cash contributions, compared to us with over 5,000. We were supported by over 1,000 active Maine citizen volunteers who knocked on doors, collected signatures, and participated as volunteers in managing the campaign. They did this because they were interested in expressing their First Amendment rights and speaking out on a policy issue that was important to them. And this includes both Gary and myself. Neither of us is being compensated for dealing with this violation or for being here today. We were not funded or motivated by any commercial interest, directly or indirectly. We were outspent by 40-1. And ironically, one of the most salient issues in the campaign was the amount of money spent by our opposition and where that money was coming from. We did not ever receive a single contribution larger than $100,000. We had aggregate contributions from ILSR and the 128 Collective that added up to over $100,000. You've read about the two violations at issue here. Let me just tell you a little bit more about them. The two major contributors. The first, the 128 Collective, is a family foundation established and controlled by a husband and wife philanthropists, Tom and Teresa Preston Werner. Mr. and Mrs. Preston Werner are very wealthy individuals. Tom Preston Werner was the founder of a company called GitHub, which was sold to Microsoft for $7.5 billion. They have, like many people who have been successful, they have decided to devote themselves to philanthropy. They provided 100% of the funding for the 128 Collective. They're entirely transparent about their donations, and they always have been. There are no other sources of funding that go into the 128 Collective, so there's really absolutely nothing for anyone to hide regarding that major contributor. The second contributor, the Institute for Local Self-Reliance, is also a respected, well-known nonprofit with nothing to hide. ILSR has been in existence for 50 years, has an office in Portland. I did a search of the web in January and revealed at least 11 entities that fund the work of ILSR. Websites such as Charity Navigator, ProPublica, GuideStar, generally give ILSR high scores for accountability and other metrics. There's a website called Cause IQ that provides additional information, including naming other funders who gave a total of $5.19 million to ILSR over the years. So as a 501c3 organization reporting to the IRS also, ILSR also files Form 990 setting forth a bunch of information about the organization. So the point here is that this is not a dark money operation. So we base our waiver request on the statute and the factors established by the commission in previous cases. 21A, 1060A 6 authorize the commission to waive a penalty in full or in part. Subparagraph 6A4 allows the commission to consider other factors when deciding how much of the penalty to waive. And several of those factors support our request for waiver in full or in part. First of all, the first factor, these violations were unintentional. These mistakes were just that, they were mistakes. They resulted from a flaw in the way we tracked contributions that did not catch contributions that exceeded $100,000 when aggregated with other contributions. I believe the information about these two contributors that I just shared with you shows that there was no incentive or plan to avoid disclosure here. We just simply hadn't encountered aggregate contributions previously, and we just had a gap in our compliance approach. Second, we acted immediately to address the problem. This is a factor the commission has considered in previous cases. And we did act responsibly, and we addressed the mistake in less than 24 hours. Of course, we cannot turn back the clock, but we immediately sent out the major contributor notices and filed them with the commission. Third, there was no harm to the public in this case because the information in the major contributor reports was already public information. In some cases, as has been stated, the major contributor report is the only way to learn of the source, the true origin of funds. And there are some major contributors whose funding is intentionally concealed. The proliferation of dark money organizations, which the commission is aware of, is the reason that drove the legislature to enact the major contributor requirement. Neither the 128 Collective nor ILSR is a dark money organization. These are above board nonprofits. Information about their funding sources can be learned by simple Google search. In the case of the 128 Collective, not only was this information publicly available, it was actually part of the discourse in the campaign long before this report would have been filed, had it been filed in a timely way. I actually have some exhibits here I'd like to share. If I can, if you don't mind, I'll just hold my bit. Sorry, I'm not going to be able to provide one for Commissioner Hastings online, but I'll try to describe them. You do the same.
I'll put one at his place.
Someday the title will get.
Right. And I want to tell you, I know I'm going on and on, but I'm not going to read all this. So if you take a look at Exhibit 1 here, this is an advertisement from our opposition. And I'm pointing this out, not because I agree with any of their messaging, but this was issued, this is a web posting that they put up. And they described the 128 Collective, not really as the money coming from the 128 Collective, but the money was coming from Tom Preston Werner himself. They're treating it as an individual contribution. So this is just to illustrate who he is and the fact that this was already part of the public dialogue. And therefore, the fact that our filing wasn't on file with the Ethics Commission really resulted in minimal lack of information to the public, since they had a $40 million megaphone and they were already talking about this. And it also further demonstrates that 128 Collective is really the alter ego of Tom and Teresa Preston Werner, certainly in the public eye, and I think frankly, as a matter of economic reality as well.
You know what the date of this ad was?
So I looked at this on the internet, and there wasn't any, I pulled this up. I remember seeing it during the campaign. I pulled it up recently. I don't know what the actual date of it was, probably over the summer. But it was in the heat of the campaign. I didn't really make a note of it at the time, but the website didn't say anything that revealed when it was actually posted.
I understand it. Yeah, thank you.
Yeah. The next point I want to make, and I'm happy to go back to that, but the next point I want to make is that these two contributions are among the smallest that have come before you since the major contributor law was enacted. If one looks to the statute, the size of the contributions should be regarded as one of the most important factors in determining whether a waiver in whole or part is warranted. It's mentioned in two separate provisions of the statute. These two contributions were quite small compared to the other BQC contributions that have been before you. And the next exhibit just shows in comparison the contributions that have been before you, and then these two contributions that are at issue today, and how they are relatively small compared to other ones that have been the subject of enforcement proceedings. And I would note that in some cases, I believe these contributions, the major contributor contributions at issue here if you aggregated them, they would have been even much larger than what's on this graph. So the small size of these contributions should be given substantial weight pursuant to the statute in granting our waiver request. We don't think it would be fair or consistent with the statute to impose a disproportionately large penalty on small contributions. The next point is that the contributions from the 128 Collective could be waived in full because they originated from individuals. The violation related to 128 Collective, it really can be considered a technicality because the 128 Collective was the mechanism that two persons used to conduct their philanthropy. And so it is essentially personal contributions from this philanthropic couple. Technically, there is the 128 collective as the bucket that the money comes out of. But this is a technicality. It's based in the sense that this is a violation. It's based on the organizational form of the entity making the contribution, not on the economics of the donation. And so, since personal donations are not subject to this rule, I think you could waive the penalty entirely. If not, you'd have precedence for, in a case that is a violation as a technicality, you have precedence for imposing a penalty of $500 on that ground, and we would ask you to consider that. The next point I'll just touch on briefly. Our campaign staff had comparably little experience running a statewide ballot question, and we had a lot of turnover. The memo in the agenda packet says that the two contributions that were earlier from ILSR should have put them on our radar screen. In retrospect, it's certainly true. They should have put them on our radar screen for another that would put them over the limit. The person who was our campaign manager and the person who was our finance director were not on the scene at the time of the earlier contributions. Had they been, I think we might have had a better chance of avoiding this glitch. But I just offer that to explain that it wasn't because of our lack of continuity at the staff level. Those earlier contributions did not get connected up with the later contribution that put over the $100,000. And I would mention that I had talked to our staff. Obviously, we had compliance conversations throughout the campaign. There was awareness of the major contributor rule and the $100,000 threshold. I had a conversation with staff. They reached out to ask me and Gary about a contribution that came in that was exactly $100,000. And I gotta say, we were getting these every day over the 3 or 4 years that we were working on this. So a contribution came in exactly $100,000, and they were like, well, do we have to do a major contributor report? And so we picked up the statute, we looked at it, and it says contributions that exceed $100,000. So I don't know, I think they may have even checked with commission staff. I'm not sure about that, but we talked about it. We said, okay, this does not trigger the requirements, so we don't have to do it here. But thank you for bringing it up, and I'm glad you're looking for it. And that was that. But they did, obviously, at a point around that same time, the other contributions went over the 100,000 mark, and they didn't bring it up to our attention. So I would just refer again to our compliance record in the We the People PAC case. The commission staff recommended a reduction in the late filing penalty on account of showing a strong compliance prior to the penalty. I think this factor also applies here. We think it should be given substantial weight. Our compliance record is far more extensive than that was involved in the We the People PAC case. Over 3 years, over 5,000 individual contributions, 500 pages of reports on time without a glitch. This properly managing that volume of transactions puts us in an entirely different category from a campaign such as Maine Energy Progress, which tripped up over the major contributor rule, even though they only received 11 cash contributions. That's all they had to track, 11 contributions, and they still tripped up. So I just want to put this in perspective, that none of the other BQCs in prior major contributor cases came anywhere close to our record of compliance and diligence. I would say the unique nature of aggregating contributions means that the error was less egregious than just ignoring the law. Some of the major contributor cases, I've listened to the proceedings and read the findings, and some of them I really can't say what the explanation was for why they failed to comply with the law. But in our case, I can at least say that, whether you think it's understandable or not, this fact of not aggregating contributions was what happened in our campaign. We did not have a system in place to add them together. And I think that's a little bit less egregious than if a contribution over the limit comes in, is over $100,000 and they just ignore the rule. Again, I'm not saying we didn't violate it, but I'm just asking for consideration on that factor, because both of them resulted from the same mistake. And I would say that in prior cases, the commission has considered counting 2 violations as a single mistake in some cases, and I think you could do that in this case as well, since the single mistake here was our failure to properly aggregate. Just have a couple more points, and I thank you for indulging me here. I think this is the first grassroots campaign to come before the commission for this type of violation. We had less staff and no legal counsel, and lots of turnover. In past proceedings, there's been some discussion of the distinction between business initiatives and citizen initiatives. I agree that this can be relevant. Now, of course, the statute does not make this distinction in terms of whether or not there's a violation, but it can be considered when determining the severity of the penalty. Along the same lines, the commission has also discussed in some cases this question of the cost of doing business, and that the penalties need to be heightened because they're being just treated as the cost of doing business. I'm not sure what the cost of doing business really means necessarily, but our power campaign was not a business. We had no connections, any business or business interests, directly or indirectly. We have no income, we have no profit to protect. We have very little money, certainly none to burn as the cost of doing business. A severe penalty here would be really painful for everybody involved. And we just think that if the cost of doing business is a factor in some other cases, we just don't think enhanced penalties against our small campaign, is appropriate on that basis. We think another point that is important to make, I think it would be unfair to penalize a BQC for having people with expertise involved in the campaign when the commission has not consistently penalized other committees for having far more expertise than we did. The past experience of myself and Gary, our treasurer, was mentioned in the staff memo, apparently as justifications for heightened penalty. Although other penalty provisions in Title 21A specifically mention experience as a factor, Section 1060A does not. I'd also point out that 1060A empowers the commission to reduce a penalty on the basis of other factors. I don't think it authorizes increasing the penalty, but maybe that's debatable. But assuming for a moment that the commission has the authority to increase the penalty based on other factors, it's understandable why the commission might want to consider the experience of the people involved, but it should include not just the experience of the people whose name is on the campaign finance report, but all of the experience that those officers utilized and availed themselves of during the campaign. If a campaign officer utilized paid lawyers, accountants, highly experienced campaign managers, consultants, I think that's equally relevant as experience or expertise. And as far as we can discern, I don't believe the commission has ever previously increased a major contributor penalty on account of professional expertise, even where that expertise was quite extensive. In the Martyr case, one of the BQC officers was a CPA who paid $29,000 for her work on the campaign. She had extensive relevant background, direct experience with the major contributor rules, and even a prior violation of those rules relating to $1 million contribution. In the Maine Energy Progress case, the BQC spent $539,000 for legal services and $132,000 for compliance services. And working with these experts, the campaign still managed to violate the major contributor rule. And in the Clean Energy Matters case, the BQC had access to legal and compliance professionals who were paid $905,000, and they retained an experienced high-level campaign manager who was paid almost $500,000 for the work on the campaign. So it doesn't appear that the commission ever increased the penalty for any of these BQCs on account of their experience. So if experience is a factor, a punitive factor, only when you're talking about volunteers like me and Gary, this kind of lends a picture of being biased against low spending campaigns as compared to those with highly paid professional expertise at their beck and call. The next point here, I would say, is something to consider. It has to do with the commission's approach in determining penalties. The commission has adopted a baseline penalty approach. This approach previously was a baseline penalty of $2,500 per violation. And I think in November, there was a staff recommendation to increase that to $5,000 per violation. And I don't know whether there was an official agreement on that, but it seems to be that's the standard going forward. Well, here's the problem. A fair reading of the statute establishes that the penalty needs to relate to the size of the contribution. The size of the major contribution at issue needs to influence the size of the penalty. Now, if you do this one size fits all approach, where a $10 million major contributor contribution has the same baseline penalty as a major contributor contribution that's $1 over the threshold, you essentially erased the legislative mandate directing the consideration of the size of the penalty. If every major contributor contribution of any size has the same baseline penalty, you essentially wiped out that consideration from determining the size of the penalty that you actually impose. And I think, theoretically, you could mitigate that by increasing the penalty in cases where the major contributor contribution is very large, but I don't think you've done that to date. I don't think I've seen that in any of the cases that I've read. You can't go back and redo those past penalties, but you can avert this inequity here in our case by waiving or greatly reducing our penalty to reflect the fact that our major contributor contributions are among the smallest in any case yet to come before the commission, as shown on Exhibit 2. I'm almost done. Thank you. The penalty determination should not favor campaigns that spend a lot of money. In at least one prior case, it was suggested that a violation was less egregious because the campaign had spent millions and millions of dollars, quote. Again, this comes dangerously close to saying that a high spending campaign gets preferential treatment. I respect the chairman's comments that we were not a mom and pop campaign. We were not a high spending campaign, regardless of how we want to characterize this. Exhibit 3 shows how we stack up compared to some of the recent BQCs that are on record in the state in the last few years. We're one of the smaller ones. And again, all I'm saying is that I would urge you to reframe the question as, do you have a substantial, extensive compliance record? Is your violation, 1% of your filing, or is it 30% of your filings? We have a small percentage of our obligations that we will drop the ball on. We're ready to take our medicine, but we just wish to keep it in perspective as to the amount of diligent work that had to be conducted and not base it on the size of the campaign spending in other areas. So we request a waiver. The staff recommended penalty is, and if you look at Exhibit 4, the staff recommended penalty is an anomaly here. It's twice that of any other penalties except for the dormant contribution. You'll see our two proposed penalties, recommended penalties on the bar graph. We think this is unwarranted for the reasons we've given. We ask you to waive the penalty. There was no harm to the public. There was no hidden dark money. At the very least, we ask you to waive the penalty on the 128 collective contribution, because that wouldn't have provided the public with any more information than was already out there. And as a matter of fact, the couple who supported that contribution were individuals, not another PAC or some kind of other entity created to obscure the source of the funds. If you do choose to impose a penalty on the ILSR contribution, we ask that it's no harsher than the penalty imposed in the Martyr case, the Maine automotive right to repair case. They have far more aggravating factors. They have larger major contribution donations. They have more violations, very long delays, access to even more extensive compliance expertise, and they were a repeat offender. There's simply no justification that I could see for their violations in the record. Their final penalty was 1.45% of the aggregate amount of their contributions. 1.45%. If you apply that penalty percentage to us, that would mean a penalty of $1,907 for the ILSR contribution. So that concludes the factors. I appreciate that these rules have a reason and a purpose, and I appreciate that you have to struggle with applying them with, trying to understand what's going on in a campaign just on the basis of my comments. I appreciate that that's not always easy. We think the spirit of the rules, spirit of the law here does not argue for a much higher penalty than some of the other campaigns and the penalties that they've received in recent precedents. So thank you for your attention. Happy to try to address any questions you might have.
Thank you, Mr. Brogan. Anybody, any commissioners have questions? Mr. Murray?
Oh, just a very brief statement, and then if I could direct a question to the executive director.
Sure.
The observation is, I've heard you use the phrase, "Why is your penalty being increased?" multiple times, when according to the formula, it would have been much higher. So the staff recommendation has actually been a reduction in what could have been levied. I just want to say that for the record. And I'm wondering if the executive director would comment on their exhibit 4 as opposed to our calculations.
Yeah, I mean, the way we've been approaching the penalties for the major contributor violations has been to try to shoot for consistency. And that's been sort of a longstanding pattern in the commission with campaign finance violations, that a lot of them are routine. And so there's sort of one range or standard that applies to PACs that made a good faith error. Their candidates, often penalties are about $200. So I recognize that this approach can kind of seem like we're flattening all of the very relevant considerations that Mr. Brodigan has brought up there. They all deserve to be considered, but that's the way we've done things. And the commission is, I mean, you can always adopt a different procedure. And I think there's sort of a policy argument here that we should be approaching this differently and deserves to be considered. But it hasn't been the past practice. The amount of the spending sort of plays into where the preliminary penalty starts out at. I guess there's just different approaches, and sort of consistency and proportionality can be reached in different ways. And the commission hasn't tended to use this sort of percentage approach. I guess it's the bottom line. Okay, what I would say you can, and I definitely think everything that Mr. Brodigan and Mr. Friedman said should be considered, and maybe that argues for less of an increase over the baseline or decrease, that all should be considered. But it's just the way it's displayed in the exhibit hasn't been our best.
Thank you.
Commissioner.
Yeah, again, some sort of comments. First, I want to say, I find this information very helpful, so I appreciate you clearly put a lot of time into this, and I think that's very helpful. So again, sort of just more in the comment than the question. Great. I'll just say for myself, a few of the arguments I found less persuasive, and some I'm finding more persuasive. I agree. I don't find persuasive your suggestion that there's a penalty for not having expertise, because as my co-commissioner said, the staff is not suggesting that your percentage, automatic penalty be increased. In fact, they're recommending a decrease. So I do not find that argument persuasive. I don't find your technicality argument persuasive, and it's in fact frustrating me that you're making it because, that's not what happened here. They could have contributed individually, but they did not. And I think that would thwart the meaning behind the requirements and the rules. If anybody, just because they were a single entity, therefore we waived it, because there's a contribution. So I don't find that argument persuasive at all. I also don't find your argument persuasive. And again, my commissioners may disagree. I'm just telling you sort of my thoughts out loud here about the other side, this advertisement about 128 Collective, who it belongs to. In fact, I think that could cut against you, because if the public wanted to say, hey, is this true? Let me go on and see if there's been a, major contribution. They would go on and say, oh, no, there hasn't. So,
That's why I asked the question about.
yeah, so Versant could be lying. So I found those arguments less persuasive. I appreciate you're making all the arguments you find persuasive. I'm just telling you that. I did find persuasive your arguments about your rate of compliance. I find that very, very relevant. I think it dovetails with I agree with the chairman that I don't think I described you as a mom and pop shop. I do think that, business versus citizen initiative and rate of compliance is really very important. And so I find that very helpful. I also find very persuasive, and again, Executive Director Wayne just discussed this, the percentage of the contribution. I do think we have these sometimes competing things with trying to be consistent, but I think the statute does require us to look at some of the specifics. And I do find this rate of penalty versus contribution, I find that relevant to a potential consideration for further reduction waiver if we get there. With respect to the single mistake, I'm sort of on balance with that. I mean, I understand that the concept is if you don't have the policy in place to catch aggregate accounts, you're probably gonna do that. So that kind of was out in the wash for me though, because what if there was 100 of them? But we're not there and then the concept of the aggregate, I do find persuasive. And correct me if I'm wrong, the previous, at least recent, penalties that we imposed for violations of this sort, those were not aggregate. Those were single donations over 100,000. Is that?
That's correct.
Yeah. So I'm also persuaded by that in the sense that why this error is different than some of the other ones we've imposed. So I am leaning towards a penalty that is less than what the staff suggested. I'd love to hear from my commissioners. I'm still sort of trying to figure out what that penalty will be. I would have been more helpful if you had suggested what you think the 128 Collective penalty should be, as opposed to just asking for a blanket waiver. But anyway, so that's sort of my thoughts.
Thank you. Any other?
I just have a question about your exhibit 1 and the information regarding Preston Warner. Where did that information come from? How did they get it? You may have addressed that and I missed it.
That's sort of the point, is that this is not a secret. The fact that Tom and Trinaires who set up a foundation is something they're very proud of. And they talk about it all the time. Their podcasts where they talk about how they want to conduct their philanthropy and they made a lot of money and now they want to give back to our community, the world, whatever. They're very interested in climate change and other things. And this is like the opposite of dark money. They're very proud of what they're doing. They talk about it all the time. How did they get the information? I mean, when they set up this 128 Collective, I think it was 2018, 2019, they announced it. They said, this is what we're doing with our philanthropy.
Okay, so the point of my question was this, to your mind, you're not saying that this information that's in exhibit 1 came from any sort of required filing with this commission?
With this commission? No. I don't know of any other mandated government filing that they.
I'm just trying to clarify that. But so this is your argument is basically there was no harm because Preston Warner's we're bragging about it essentially publicly. Is that your guess?
That is, that's one way to put it. One of the factors that's been used is whether, in past cases, was whether, what was the harm to the public from denying them this information? And the information, I believe, the information is not a black and white report that's with the Ethics Commission. I believe the information is the content of that report, is the information about like where are these contributors really coming, where are the contributions really coming from? That information, our opponents had millions and millions of dollars to talk about that, and they did. And so my point is that I'm not saying that it excuses a violation. I'm not saying that we'd ever do it the same way again, and we certainly wouldn't. But all I'm saying is that in a case where you have sort of this report reveals something that nobody ever knew. That's not what we have here. We have a case where not only was the information available if someone just bothered to do a Google search, but it was already in the discourse of the campaign. It was already being talked about. And, that somebody who really was kind of a nerd about these things might go onto the Ethics Commission site and see if they can look up, the major contributor report and verify it or not. That, yeah, but in terms of
The press might, not just a nerd.
Sure.
Yeah, this was heavily covered by the press.
I get what you're saying, but the commission's rules are designed to give accurate information to the public, not to simply rely on the kindness of strangers and
that's why
delivering information. So I get your argument on the harm to the public, and I don't quite buy it 100%.
Thank you.
It's not reliable, it's fine print on where did this just, it was just like
It's a website.
A website thing, so.
And I'm not saying that that's the only place where this occurred. This is the only thing I presented to you today.
I just wanted to make clear that this information didn't come from some sort of verifiable source as a commission filing would have been. Thank you.
Thank you.
Commissioners, any other questions or comments? Commissioner Hastings?
Just one comment. I keep hearing that these contributions were considered to be, I can't draw the distinction between what is characterized as a virtuous contribution versus a dark money contribution. I don't think that's something that we should be even taking into consideration as a commission, and it's in the eye of the beholder type of thing. And I have kept hearing about how these were good people and it's a virtuous contribution, and as opposed to the other side, which I think is being characterized as dark money type thing. And I don't see that as a consideration that we should be even talking about.
I don't know. Chance to respond to any of these comments.
You can respond to that, sure.
Yeah, maybe there was a glitch in the audio because I did not say virtuous. I didn't mean to.
Well, he was characterizing your.
Oh, you never use that word, but I took it as that was essentially
Dark money is a term that is in common parlance in the world of campaign finance. It just means money that's, there are ways to set up a daisy chain of different corporations and nonprofits and C4s to conceal the real source of funding. Some people do that because they don't want anyone to know. And, they may be more or less successful at doing that. This is not news to the commission. All I'm saying is that this was not one of those instances. I'm not saying that the law didn't apply to us. I'm just saying this is not a case where, everything was hidden until the requirement of the statute, kicked in. This is not a case like that. And in past cases, the commission has looked to whether the public had access to the information and considered that in weighing whether or not to waive a penalty in full or in part. Two more things. One, I did say in our initial filing, we asked for the whole penalty to be reduced to $1,000. if the, commission, were to impose a proportionate penalty as they did in Martyr to both the two contributions, we would certainly, take our medicine and accept the commission's determination. So, I didn't want to be vague about what we would accept as a penalty. The final point I want to make, I want to go back to this question of the proportionality. Yes, there is a range between sort of what's been called the standard penalty, like $5,000, and the statutory penalty. There is a range in there. And I think some of my argument has been discounted because your point is that, this is just all up for review and consideration, and it's not that we're saying that you only have the statutory, you only get the penalty of this like new standard, the only $5,000. That's not the final word on the penalty. I get that. My point though is that I've looked through all the cases and I haven't seen anywhere where you actually have increased that $5,000 on account of the size of the contribution. I think if that argument was convincing, you'd be able to say, yeah, see, look, the 5,000 was just sort of a starting point, and where the large contributions are involved, we go up to 10,000. I could accept that argument, but you've never done that, as far as I can tell. So you're starting with a baseline, and the statute says you can waive in whole or in part. You're starting with a baseline, and in most cases, I think you've actually imposed something close to the baseline or the baseline. And my only point is that if you're going to make the argument that we're still doing it proportional to the size of the contribution as the statute requires, there should be some examples of when that's actually been, when you've actually shown a larger penalty for a larger contribution. I haven't seen those. So sorry to go on. Thank you for your consideration.
Commissioner Marvel.
Commissioner Newman asked a little bit ago, she offered her own observations and asked for some response from us. So I just wanted to say, I thought everything she said was spot on. And I'm in agreement with her thinking.
Any other questions or comments for Mr. Brodigan? Commissioner Hastings?
No.
Okay, thank you very much for your testimony.
I appreciate it. Thank you.
So we move on to the decision part of the hearing. And we, I think, both of the representatives don't take issue with the fact that there were 2 violations here of their requirement to notify major contributors. So we don't need to address that. The combined penalty that was figured out statutorily was $28,155.08. And it's up to us to decide whether or not we want to waive all or part of that. We should start with a motion. Does anybody have a motion?
I'll make a motion, and I'll apply for discussion on this motion.
Oh, well,
that we, assess a penalty of $3,000 for each violation for, a total of $6,000. Basing on that and the reasons I previously said, and I've got that $3,000 because again, I'm trying to do this sort of consistency versus individual factors. And I know that we did assess a smaller penalty of $3,000 on the Versant Power case. So that's how I've come up with that number.
Is there a second?
I'll second that.
Okay. Now discussion. What do people think?
This isn't germane to the amount in motion, but I do want to reflect back that a lot of parties have come before us in the time I've been here and would have loved to have had the representation offered today by Mr. Brodigan and Friedman. I'll just say that as an observation. I'm far from greatly comfortable with anything I think we might do. I'm still a little bit back and forth on this, but I can nod my head with the number in the motion, we'll support it.
To me, honestly, I'm more inclined to go towards the staff recommendation. To me, this has a couple of serious implications. The first is the claim that this was a fairly large, I mean, in the history of Maine politics, we have seldom seen a group that spends $1.2 million on ballot questions over the course of a couple of years. And so this is a fairly large endeavor in the course of Maine politics. And I think that if you're going to run a large endeavor like that, you are obligated to have the expertise on hand to follow the Maine election law. And I think claiming that you were inexperienced and had lots of contributions, lots of small contributions and stuff, doesn't hold much weight with me, because I think if you're going to do this in Maine, you ought to be following the rules, and you need to have the experience and the expertise available to follow the rules. The second factor that really aggravates it for me is I mean, both people who testified claim that there was no harm to the public, but that's absolutely not true. I think these major contributor reports, particularly in a campaign of this intensity and this emotion, covered so heavily by the press, these major contributor reports are a red flag to the public that someone is trying to influence their vote. And I think it's important, really important, I think, for the people of Maine to have this information before the election. And in this case, the fact that the major contributors weren't required to file reports until after the election denied the Maine people that important information. I think the factor weighing on the side of the organization is the size of the contributions. We've dealt with much larger contributions in the past. But I think at the very least, the $5,000 that we have discussed, this to me is more serious than the average offense under the failure to notify major contributors. And so that's why I would be inclined to go more towards the staff recommendation. But in the interest of compromise, I think I'd move to amend the motion and to impose a fine of $5,000 for each offense. Is there a second?
I'll second the amendment.
Okay, now let's discuss the amendment. Anybody have anything else to add?
Well, I'm not opposed to your amendment. I think that your points are well taken, especially the fact that the information was not provided till after the election. I'm inclined to reduce because of the level of this organization otherwise complying.
Terrific.
And I will say, I won't be voting in favor of your motion, again, for the reasons I said, but particularly because of the rate of compliance. I mean, I agree with what you say. I absolutely agree this was a violation and there was harm to the public. But like I said, the rate of compliance and percentage of contribution, I think, are relevant. And again, we also haven't had an issue where there's an issue of an aggregate donation. So, and what I just said.
Any other comments, questions? Okay, so let's have a vote on the amendment. The amendment is to impose a fine of $5,000 on each offense. And we'll do a roll call vote. Commissioner Newman?
No.
Commissioner Marvel?
No.
Commissioner Leclerc?
No.
Commissioner Hastings?
Yes.
And I'll vote yes as well, but the amendment fails. So we go back to the motion to impose a $3,000 fine for each offense. Is there further discussion on that? Seeing none, we'll have a vote. Commissioner Newman?
Yes.
Commissioner Marvel?
Yes.
Commissioner Leclerc?
Yeah.
Commissioner Hastings?
No.
And I'll also vote no, but the motion prevails. So we're gonna impose a $3,000 fine for each offense, total of $6,000. Thank you, and thank you for your presentation.
Thank you.
Thank you very much, commissioners. Appreciate your consideration.
Okay, moving on to agenda item 4. This is the complaint about a 2022 flyer in House District 52. Mr. Wayne.
Sure, this is about a flyer that was sent shortly before the 2022 general election. And it was included in a newspaper style.
I have someone that's.
Oh, yeah, I'm sorry. Yeah, I should have been more.
Yeah, I'm sorry. I've asked him to. Okay.
Mr. Roy, are you there?
Yes, sir.
Okay, terrific. And you're Mr. Levita, correct?
Yeah.
Terrific, great.
So it's about a mailing that was received by voters in Bowdoin and Bowdoinham and Richmond and some nearby communities around October 29th. And the complaint that we got from Ms. Jennifer Small was about a flyer that was included in the newspaper. So the newspaper is entitled The Maine Anchor. But the complaint really is about the flyer that was in the newspaper, which is about Sarah Clucci. And it was critical of Ms. Clucci on issues of books in schools and vaccines and things like that. Back in October, the commission authorized the staff to conduct an investigation. The two compliance concerns that we raised at the time were, did the flyer contain the full disclosure of what were the names and the addresses of the persons who financed the communication? Did any candidate authorize the communication? So there was a disclaimer, set of disclaimer concerns. Also, did the folks involved have to file an independent expenditure report? We knew Mr. Levita was associated with the Maine Anchor, so we were trying to get in touch with him. We did not successfully reach him at one point, but conversation was shorter because he was ill at the time. I very much appreciate that he called me back about 2 weeks ago in response to a letter I sent him. And he provided some information to us about the cost. I think I won't go into that now. We're pleased that both Mr. Roy and Mr. Levita are participating today, so they can, if you have questions about the cost, they can answer that. What we described in the memo is that occasionally these situations pop up where people feel very passionately about candidates, but they don't have a lot of personal experience as outsiders to a candidate's campaign, and they get involved in communications to the public, but they may not be aware of all the legal requirements associated with that. And I've seen commissioners try to approach these situations in the past. It's hard to generalize, but I think commissioners have at the same time wanted to give credit to the idea that everyday people may not know all of these laws and what they have to do. At the same time, commissioners have felt the need to stick up for the value of disclosure. And I think the value of the paid for message in the bottom of these communications is that it gives people, everyday people who receive these communications, the tools to know who's paid for them, and it gives them information about how much weight they want to give to the communication and what are the potential biases, who's this person who's talking at me in this group of advertisements, mailings. It's valuable for voters to have that information. So finding a violation, it seemed to us there was at least a violation with regard to disclaimer. I think finding a violation would be appropriate to reinforce that this is important. We've made some comments in the memo about possible penalty, but we leave that in your discretion.
Terrific, thank you.
Yeah.
Any commissioners have questions of Mr. Wayne? Commissioner Hastings?
No.
Okay, terrific. Mr. Levita, well, actually, is Ms. Small here? Okay. Mr. Levita, would you like to speak?
Sure. If you want to sit up there.
Yeah, please. And come up and introduce yourself and tell us whatever you'd like.
Well, thank you for inviting me here, commissioners.
Mr. Roy's on the screen, just.
He is.
Can't see.
Mr. Roy's kind of up on the top.
Okay. Too small for me. Thank you.
My name's Scott Levita. I'm a Christian, I'm conservative. I'm the owner and the editor of the Maine Anchor newspaper. We put out 3 editions in the past year and a half, 2 years. The next edition of the newspaper will be coming out next week. I fully intended to do a newspaper every month. I'm a self-employed building contractor. I've been self-employed here in the state of Maine since 1977. I moved here from Germany, went to Penn State. I'm a naturalized citizen. I was born in France. I served in the Maine Army National Guard as a combat engineer. I just want to serve my state, and that's why I'm doing the newspaper too, to print the truth. And let the facts fall where they may. I've also run for office several times. Okay, so I know, just to give disclosure, I've run for state senator, state rep, county commissioner twice. The second time was just like a write-in, not a write-in, but a placeholder. Came close to winning 3 times with 45, 46, 47% of the vote. So I know the ethics rules for a candidate. I was not a candidate when I started the newspaper and inserted this flyer into the newspaper. I had no idea that a newspaper owner and editor had to disclose things like this. I had no idea. So I put a retraction in this edition of the newspaper to correct the situation of paid for by concerned parents of SAD 75. I am a concerned parent. I'm a grandparent too. I have 10 grandchildren that live here in the state of Maine. And 1 down in Florida, number 11, soon to be an even dozen. I get involved and I'm helping the state of Maine because primarily my grandchildren are concerned about their future here in the state. I'm really concerned. So I believe the newspaper has a First Amendment right to print. And as I said, it's a Christian newspaper too. And I'm also all about equal application of the law. I've never had any ethical complaints while I ran for office. Emma Burke, she handled all of them and I complied with everything. You know, I had no idea that I was violating, you know, a Maine rule. And Jonathan, I was intending to come here and be present in the Zoom meeting, but I got rained out today. I'm a contractor, and the job that I'm doing on one of the peninsulas here in Maine, I'm waiting for the plumber to do their thing so I can do my carpenter thing. So that's why I'm here today. Okay. So I'm happy to answer any questions.
Great, thank you.
Yeah.
Any commissioners have questions? Yes.
You just mentioned about the retraction. Can you just let us know, or is that in here?
It's in the upcoming.
Edition.
Oh, okay. Can you just
Yeah.
tell us what that will say?
That we made a mistake about, I should have had my name after paid for by concerned parents of SAD 75. My name is all over the paper. Okay, in this edition, it's gonna be on page 4, so you can look for it. So we put a, not just hidden retraction, not just like buried deep within the paper, but full article on it and why and what happened. So you'll see the retraction, and then we also, to give context to the whole thing, look on page 4 and you'll see it.
Commissioner Murray.
Just a straight business question, actually.
Sure.
I'm not imagining you've made millions over this effort.
With the newspaper?
Yeah.
No, it cost me thousands every time I do this.
Okay, I was just wondering about your distribution and your own costs.
Oh, sure.
Do
So,
people pay for this? How does that work?
very few people subscribe to it. Maybe a dozen will ask for a copy, or 10 or a dozen to be sent to them. So we mail it to complete zip codes, or at least several of the mailing routes in each zip code. And in the past, I've sent it to towns like I think Tennant's Harbor, Harrison,
Durham, Pownell, Bodenham, Bowden, Topsom. You know, this time, we're actually sending it to Camden too. So in the newspaper, we're an independent newspaper, so I even put articles where I don't agree with Senator Susan Collins in there, and you'll see that in this edition too, but even the third edition that we put out. So it's not just going after a certain political party, it's anybody, I think, that's not doing the right thing for the state of Maine.
So just to follow up, is this a newspaper or a vehicle of opinion?
No, it's a newspaper. Full size paper, you know, offset printer. It's a newspaper.
We'll leave it at that.
Okay. Any other questions or comments from?
I don't know if it's in the materials, Chairman, but so the paper that had the flyer, how many did you send out?
Statewide, 6,000.
And do you do that through some sort of bulk mailing?
Yes.
Thing, and so, but for 6,000, what does it cost you to do that?
Oh, it's like mailing costs, year and a half ago.
Yeah,
I think it was like total mailing cost, maybe $1,200, something like that.
Are there any, paid advertisements in the newspaper? Like,
No, nobody has the courage to put a paid ad in so far. This edition, the fourth edition, I think there is gonna be one paid advertiser.
and you speak of a retraction, so the retraction is that the proper term for it? Is it a clarification of the status of the disclaimer be a better word?
So nothing on the actual flyer that was inserted into the paper is a correction. It's just the disclaimer correction. I put my name on it.
So it's not, you're not retracting this flyer, what you're doing is saying you're correcting the disclaimer,
Disclaimer, correct,
putting the proper one in.
correct.
Are you sending this out again?
Yes,
But with the proper
correct.
disclaimer,
Right.
okay?
So as I understand that, and I had no idea about this rule, that after Labor Day and during election year, that the rule changes. I had no idea.
If you name a candidate and your publication is clearly advocating or arguing against that candidate,
Mhm.
it requires that disclaimer.
Yeah, I know that now.
So this was a 2022 campaign, is correct?
Right.
Yes, and I was not a candidate myself, and in fact, I don't even live in that district that Representative Sally Pucci represents.
Any other questions from commissioners?
No.
Commissioner Hastings?
No.
Okay, thank you, Mr. Levine.
Welcome.
Mr. Roy, would you like to say something?
Well, I'm not sure what I can add that Guy hasn't already mentioned, but just to introduce myself, again, my name is Brian. I live in the town of Bowden. I've worn a bunch of different hats in my life. I've been in the Army. I was in the 82nd Airborne as a medic. I did a couple tours in Iraq. I worked in adult mental health for a number of years, and evidently now I'm dabbling in newspapers. Although I got to say, I've never faced off against John Wayne, so I don't know how this is going to work out. But of course, I'm joking. So anyway, I think Guy really summed up, as far as my understanding, my role on this particular flyer was pretty limited. It was very nominal donation towards that. I have done some writing for the paper with other articles. You'll see one in this current edition that I'm pretty proud of, actually. But I think that's it as far as I can tell you. Unless you have any specific questions, I'd be happy to answer them.
Great, thank you. Well, I want to let you know it's nice to hear from another paratroop.
Thank you.
Any other questions for Mr. Roy? Commissioner Hastings?
No.
Okay, thank you, Mr. Roy. Thank you, Mr. Labita. Now we come to the decision-making part of the exercise. We probably should seek a motion. To me, I think it's clear that there was a violation of the disclaimer requirement. I don't think there's enough evidence to prove an independent expenditure requirement, to me. And I think that the violation of the disclaimer requirement is fairly, well, pretty darn minor in comparison to others, especially since they're going to correct it in this upcoming edition of the newspaper. So I would move first that we find that there was a violation of the disclaimer requirement.
Second.
Is there any discussion? Okay, we'll move to a vote. Commissioner Newman,
Yes.
Commissioner Marvel.
Yes.
Commissioner Leclerc.
Yes.
Commissioner Hastings.
Yes.
And I'll also vote yes. The second issue is regarding the penalty. And to me, this seems like a very minor violation, except, or especially in view of the fact that it's going to be corrected. And I trust Mr. Levy will follow through with correcting it. So I would move that we impose a fine of $25. Is there a second?
I'll second that.
Okay. It's been moved and seconded that we impose a fine of $25. Is there discussion?
Well, the basis of your motion is being a correction. Coming well after the election.
That's
I
true.
mean,
That's true.
2 years.
Yep.
So I don't know that that's in my mind, that's really not relevant anymore. It's purposes to inform the public. This is informing them of something that's no longer relevant. So
Yep.
I don't find that to be persuasive at all. Perhaps others can speak. The commission cited other penalties for campaign signs and whatever.
You want to make a motion to amend?
Well, I'm inclined to go with staff's recommendation,
Which was $200.
$200.
Okay.
That would be my amendment.
It's been moved to amend the penalty to make it $200. Is there a second?
Second.
Okay. It's been moved and seconded to amend the penalty to make it $200. Is there discussion?
I just got a quick clarifying, so I know it's right here in front of me, but I can't find it. The other penalties that have been imposed, violations of this type.
I think they were in the range of $100 to $200, that correct, Mr. Wayne?
I mean, I think if we went back in time, they probably are in the range of 100 to 200. I mentioned two. And this is on page 7 of the staff memo. There were a couple of cases that came before you in this time in November of 2022. It had to do with signs where they were either for or against Governor Mills. In one case, the anti-mill signs didn't have any kind of disclaimer on them whatsoever. And then the ones that were for Mills, it was like, they called themselves the York Citizens Alliance, but it didn't really give much indication about who they were.
I do remember this.
And they came for you in a little bit of a different posture. There was, the people involved were persuaded to file an independent expenditure report. So it was presented to you as a waiver situation where there was already like a preliminary penalty. And the decision for the commission was how much do we reduce the penalty?
The statutory.
The statutory penalty. So there's already something owed and you were deciding proportionally what to go down to. So, but I think if you went back in time, there have been instances where there was even more leniency and penalties were $100 and so forth. I just didn't go back that far.
And in
Thank
both
you.
of those cases, I'm sorry, you mentioned it was reduced to $200.
Correct, yeah. And that was really a soft recommendation by staff, just to give you
Yeah,
a
sure,
possible number, not
sure.
really.
We're not obligated, we're not
Yeah,
bound to that.
yeah.
No. Yeah.
Based on that and the precedents and Commissioner Leclerc's comments with respect to the correction occurred, after the election and therefore being less impactful, I'm supportive of the motion to for the penalty be $200.
Any other discussion? Commissioner Hastings?
No.
Okay, we'll hold a vote on the, yeah,
What
go ahead.
What is the amendment right now before us?
The amendment is to assess a fine or a penalty of $200.
Okay, thank you.
We'll go ahead and have a roll call vote. Commissioner Newman?
Yes.
Commissioner Marvel?
Yes.
Commissioner Leclerc?
Yeah.
Commissioner Hastings?
Yes.
And I'll vote yes as well. So we're going to impose a fine of $200. Thank you for coming, Mr. Levita.
So I have one other question. if I
Yeah,
may.
sure.
Has the newspaper in Maine ever been fined for, this type situation?
I don't know.
Okay, thank you.
Could I just add one more thing, just as a closing thought? One of the commissioners mentioned that, this was a correction that's 2 years after the fact. And I'd just like to point out that the complaint, I believe, was about 11 months after the flyer first came out. And I think that just kind of speaks to the nature of the complaint, and less to the content of what we actually put out there. Thank you.
Thank you, Mr. Roy. Thank you both for coming and for filling us in.
Absolutely. God bless.
You too. And let's move on to agenda item number 5, a balance adjustment for the Senate Democratic Campaign Committee. Mr. Wayne.
I'm going to make a couple of comments and then turn it over to Emma Berg.
All right.
In early 2023, we embarked on a project to contact every PAC. And when I say we, it was really Emma Berg.
That was the royal.
Yeah. And well, because of some law changes at the time, we wanted to know exactly what was their cash balance, their actual cash balance as of the end of December 2022, and that related to these law changes. Plus, we think it's good for disclosure. We don't want PACs to have an appearance in their campaign finance reports of having a lot more, a lot less money than they actually do. So as Emma can explain, she worked with all the PACs, and
Yeah, this is part of a big project to get everybody
Yeah.
reconciled.
yeah, and I think this is the
Fix
last,
them all, Emma.
the last of the group that we in that time period. This is a very large PAC. I don't have the exact figures in front of me, but I think in the last 10+ years, they raised and spent. Yeah, I can't remember, but it's a lot.
It's around 20 million.
And they made a sincere effort to identify reporting errors, which they describe in their letter. And they have now gotten it down to 19,840. And the staff recommendation is to enter an adjustment in that amount so that moving forward, the reported cash balance will correspond to what their actual cash balance is.
Terrific. Great. Are there questions for Mr. Wayne? Comments? Ms. Burke,
Hello, good morning.
welcome.
Thank you. So neither representative, the current treasurer, or excuse me, the finance director, not the treasurer, and the principal officer could make it today. They have essentially authorized me to speak on their behalf. They also did send in an extensive letter explaining their balance discrepancies that they were aware of and the amount of work that they have done to correct them. I wanted to explain part of the delay because obviously we're well past the last group of these that you have heard. Part of it was from my recollection and my knowledge, this is the highest raising and spending PAC in the state. They're also one of the oldest. And so they decided when I sent the notice out and they immediately said, our balance is, over $100,000 incorrect. We will undertake an internal audit to fix this. I was like, great. I don't have to do that. So they worked very diligently to fix these. Some of the corrections they found were down to cents that were probably just key errors. There were some missed contributions, some missed expenditures. Overall, their accuracy for a PAC that brings in several million and spends several million a year, their compliance is very high. They work very hard to stay compliant, as all of the caucus PACs do. Part of the issue we ran into is when they were ready to do their amendments. I think the number 55 is sticking out in my head, but they had a number of amendments to make going back to reports. First is we had to alter the commission website to let them amend further back than the system was set up to let people amend back. And then when they did so, the amendments, for whatever reason, did not change. this meant that I had to go back through the entire current history that we have going back to 2013 on our e-filing website, unfile every single report they had reported, check it in so it didn't show as late, and then refile them to make sure all of the balances that they had now amended were correct in our e-filing system. So it has been a massive project on their end. It's been a big project on my end. And I don't think it's around, it's not exactly the figure in the memo anymore, because again, time has passed since they have written that. We've gone through another reporting period. But considering the amount of detail they found going back years before, so Damian Bosarte, who was the finance director previously, he and Lillian Herman, I mean, they went back through like dozens and dozens of reporting periods and bank statements to fix as much as they could. I am confident, and they are confident that they can't find any more. I mean, they have found a huge amount already. And nothing we're seeing was like a concentrated reporting period where they just like kind of lost track of things, or there was a significant amount of activity left off any single reporting period. So I am personally comfortable with them receiving a balance adjustment. And they feel that's kind of what they are left with, but that's part of the reason why it's also been so delayed, is it took them over a year to do this work. They were possibly gonna come before you last meeting. I had surgery last month, so the timing didn't work for the last few months to get them on the agenda either. But they did not delay when I initially sent out my request to do this. They have them.
Are you confident that they have measures in place now to prevent this from happening again?
Yes, and from my understanding, a lot of what they did find was before Ms. Herman took over. Mr. Bosarte has moved on. They now have another finance director, Janine Gaspari, she immediately contacted me, had a Zoom meeting with me, was like, what do I do to keep this from ever happening again? So they are very much, they have initiated new proceedings and have also said they will be doing their own audit at the end of every year from now on to make sure that they never have to look 5 years plus back again, which a lot of PACs have said that now that they've gone through this very long process. So.
Commissioner Marble.
So if I'm translating what I'm hearing,
Mhm.
you put in an S-ton worth of work along with them.
Yes.
You're giving me nothing but positive vibes about their work, how things have changed.
Yeah.
Going forward, I guess the only concern I have about going forward is to make sure they memorialize whatever the heck they're doing internally.
Yes.
I did note in the very last page of the handout, about $26,000 worth of underreported, to me, large amounts.
Mhm.
There's 10 grand from something, Planned Parenthood, 5 grand from Pierce, et cetera.
Yeah.
There's several. Because these are as recent as July of 22.
Yes, and from my understanding, while those seem like very large numbers to essentially everyone else, those are everyday checks for them. And from my understanding is they didn't have a great A to B to C process set up, so only one person was getting checks and one person was entering them. It was that multiple people were, so I think one person thought the other person was doing it and one person thought the other person was doing it. That has definitely been corrected.
Okay.
And that was something that they, apologized to me too. I mean, overall, again, that amount of contributions they miss, when you look at the total amount of contributions they brought in, is a very small percentage, but I mean, by itself, those are obviously still large checks to have missed inputting. But I also made sure I looked at the beginning balance, the original reported balance, and then the amended balance to make sure that no report looked like it was a significant amendment, as in the original version essentially was not filed on time because it was so inaccurate. And none of them changed much. If you were to look at it as a member of the public to like get a general idea of how much is this PAC bringing in and how much is this PAC spending. When you change hundreds of thousands of dollars or $1 million+ by $20,000, it doesn't really change your idea of how active this PAC is.
I'm sorry.
Oh, go ahead.
In the letter that Ms. Harmon submitted, she indicated that other PACs in the past have had similar adjustments. Is that accurate?
Yeah, I mean, certainly that you did pretty significant adjustments for the Maine Senate Republican Majority PAC and the House, the HDCC PAC. So certainly those are, I mean, in the same realm. Their figure might be slightly larger, but I think when you are also looking again percentage wise, how much they're having corrected on their overall activity versus, you know, the other two caucus PACs. And I think we're looking at nothing you would be doing today would be inequitable to what you've done for other PACs. in the past.
Great.
Thank you.
Any other questions, comments? Commissioner Hastings?
No.
Okay. I will move that we direct the staff to make a balance adjustment of $19,480.54 in order to bring the Senate Democratic Campaign Committee balance into the real world.
I'm gonna, I think, vote against that motion because I think what we need to do is not be so specific.
Oh, really?
Yeah, because we've gone through another reporting period, that
Oh.
19,000, so just so we can get it exact, it would be a balance adjustment to correct their balance.
Okay,
That's it, and that's also the same motion you made for other previous.
so I would like to rephrase my motion to direct the staff to make a balance adjustment to correct the Senate Democratic Campaign Committee's final balance.
I'll second that.
Thank you.
I don't want to have to come back to you.
No, I appreciate it. And thank you for squaring that away. Is there discussion? No. Okay, we'll have a vote. Commissioner Newman?
Yes.
Commissioner Marble?
Yes.
Commissioner Leclerc?
Yes.
Commissioner Hastings?
Yes.
And I'll vote yes as well. Thank you.
Thank you.
And thank you for your effort on that project. That was a big undertaking.
Yes.
But it's important. I mean, it's
Yes,
important
it is. And
for our records to reflect real life.
incorrect balances will only grow if you don't correct them.
Right.
And like I said, most of the PACs I've talked to is now that, you know, no one liked going through this process.
Right.
So as far as they'll make sure that now that we've all gone through the growing pains of getting everyone accurate to stay accurate. And hopefully with technology, we also won't be going through any of the conversion issues that could have caused issues.
Right, exactly. So, well, thank you very much. Mr. Wayne, is there anything else we need to deal with?
No other business.
Son of a gun? Would anybody like to make a motion?
To adjourn?
That would be an appropriate motion. Is there a second? All right, it's been moved and seconded that we adjourn. Commissioner Newman?
Yes.
Commissioner
Yes.
Marble? Commissioner Leclerc?
Yes.
Commissioner Hastings?
Yes.
And I'll vote yes as well. Thank you all. Thank you, everybody. Thank you, Julie, that was flawless.
I got it in the recording.
It's officially on the record.